Well, when you take the cap off your bike tire or your car tire, it's not supposed to explode on you, right?
Not supposed to.
For Brian, so Brian went to the Kroger on that day and began working, and when he took the cap off, there was no valve inside, and it literally exploded toxic refrigerant into the air and started spraying all over the Kroger, and it's very highly pressurized. I think it was what, like 150?
250. I thought it was 250, yeah.
250
PSI. And it was not just air, it was toxic, banned refrigerant. And it started blasting him in his face. Welcome to a special edition of Cases Gone Wild with me, your host, Jon Marko and Marko Law. Today we have a very special show. It's a little bit out of the ordinary because we're going to be talking about our recent landmark, groundbreaking $77 million verdict against the Kroger Corporation in Oakland County Circuit Court. Very special case, very special client. We're going to break it down, talk to you about the case today. Remember, please watch us. We're filming on video on our new and improved YouTube channel. You can watch us streaming or go to markolaw.com and make sure to give us thumbs up and share with all your friends and family. I want to thank everybody for being here today for this special episode. Tyler Joseph, attorney extraordinaire, Samantha Teal, litigation consultant, who you've been on the show before. We've worked together for a very long time.
Thank you.
And Jon Eads, managing partner of Marko Law, who's going to swap out here today too. Thanks for being here, guys. I mean, this was really a landmark case. It's reported to be the largest premises liability case in Michigan history, as well as the largest loss of consortium claim in Michigan history, which we'll talk about and explain and break that down a little bit. But let's give an overview of kind of the case. So our client, Brian Mierendorf, was a pipe fitter, wonderful human being, wonderful family. Married, has 2 kids, hardworking guy, got a really good job through the Pipe Fitters Union, which is a very well-paying job, but you have to work your butt off to get there. Right. Was sent into the Kroger company in Bloomfield Hills. I think it was store 440.
Yep.
It's on like the corner of what? Do you guys remember?
Maple and Losser, I believe.
That's Maple and Losser.
Yeah.
Yep.
And we're going to show some pictures here. So Zach, show some pictures of this cooler that he was required to work on. For our listeners, if you've ever been to a grocery store, you obviously know there's like coolers everywhere, right? Well, unlike your fridge that you plug in at your home that just starts cooling stuff based on all the coolant being inside of it, because there's so many coolers, it's like a centralized system that pumps coolant throughout the entire store. So there's pipes that go to each freezer, there's pipes that go to each cooler, and those pipes carry coolant or refrigerant that help make the freezers and refrigerators cold, and really, really cold. Because as you can see from this picture, like sometimes you go pick up your turkey, it's like the freezer's open, right? There's no lid on it. Like at home, you just put your hand in.
Yeah.
And this Kroger used a very old and antiquated refrigerant that is very dangerous and toxic and was banned by the Environmental Protection Agency. For being so bad for the environment and bad for people, and it stays in the atmosphere and all kind of horrible toxic stuff. R22, yeah. So Kroger wanted to change its system, and they had to because of federal law, to go to a more environmentally friendly refrigerant to power all of its freezers and coolers. And in order to do so, they had to make certain changes and upgrades to the system. So these freezers, you have to change out little valves. And let's show a picture of the valve, Zach. You can see these valves. So as you can see, it's like a little pipe, and at the end of the pipe, there's a little cap. And in that, there's a little valve similar to like you have on your bike tire. You guys ever pump up your bike tire?
Yeah.
You know, it has that pointy thing, or your car tire. Well, when you take the cap off your bike tire or your car tire, it's not supposed to explode on you, right?
Not supposed to.
No.
Right? And the air's kept in. Well, for Brian, so Brian went to the Kroger on that day and began working. And when he took the cap off, there was no valve inside.
Mm-hmm.
And it literally exploded toxic refrigerant into the air and started spraying all over the Kroger. And it's very highly pressurized. I think it was what, like 150?
250. I thought it was 250. Yeah.
250 PSI. So like, you know, your bike tire, like I have like a racing bike, like you pump it up to like 80. Mm-hmm. This was at like 250, right?
Yeah.
And it was not just air, it was toxic banned refrigerant. And it started blasting him in his face. There's a video we can show at the end. We did a recreation, so we can show our viewers this video at the end of what exactly happened. But Brian takes his cap off, explodes in his face, toxic coolants going everywhere. There's kids around. Remember, this is the middle of the day at the Kroger store.
Yeah.
So this isn't like, you know, they're doing it at night. Kroger had them work in the middle of the day.
Mm-hmm.
And it's spraying out and creating a cloud of toxic fumes and vapor cloud that's hanging in the air.
Mm-hmm.
And Brian doesn't have any chance to think, or he just is a hero. And he jumps and he grabs another cap and tries to cap the line to save the people around and save himself. And in doing so, it injects this toxic refrigerant actually into his hand.
Yeah.
Underneath the skin. Almost imagine a doctor taking a needle of toxic coolant and injecting it in a shot in your hand, because that's what happened to Brian.
Yeah, his hand got frozen to the pipe.
Hand got frozen. He had to rip his hand off the pipe, and it's still spraying out.
Mm-hmm.
And Brian jumped into action and had to climb all the way to the roof of this Kroger because they didn't have any shutoff valves.
Mm-hmm.
Normal places, like you go to like your Walmart or Target now, you can turn off each cooler right there.
Yeah.
They're localized.
They're localized.
Yep.
Brian couldn't do that. So he had to work on this system that he couldn't turn off. That was, the shutoff was on the roof.
Mm-hmm. And
you had to climb like 2 or 3 ladders to get there. And he did this while his hands were literally melting off. Horrible injuries. We're going to talk about some of the challenges here, Tyler, because I know you worked this case up. But he ended up having over 20 surgeries.
Mm-hmm.
They chopped off a lot of his fingers. And he had painful surgeries. They harvested skin from his body. They cut skin off of his legs and thighs. Here, let's show this picture from Dr. Shapiro. This is this stuff. As you can see, the surgeon literally found this toxic coolant bubbling out of his hand, and it literally killed his hands from the inside out.
It was like soda pop.
Yeah, over a period of months too. This wasn't like a one-time deal where he goes in and gets a surgery and then starts the recovery process. He was in the hospital for 6 months, I think. And it was just, he had to slowly watch finger by finger come off.
Amputated. So, you know, they'd amputate, they'd say, all right, Brian, we're going to see what happens. But his hands were so bad, more and more of his body just kept dying because it was necrosing. They described it as mummified. The doctors they didn't know what to do. He had the best doctors in the country for this. I mean, we had Iraq war surgeons and stuff. They started sewing shark skin onto his hands. They started taking dead bodies from the basement of the U of M hospital and cutting skin off the cadavers and putting that on. They did everything they could.
Yeah.
But it was horrible. And Brian never will be able to work again. It's completely upended his family life. And we sued Kroger because Kroger didn't do what they were supposed to do, which we're going to talk about. And they were just callous and took no responsibility throughout this entire case. We gave them multiple chances. We went to multiple mediations, and they just said, we don't care. We're not going to pay. At first, they said, we're not going to pay anything.
Mm-hmm.
A penny. Sue us. So we did, and now they have to pay the price. And we're going to break it down on how we got this great verdict. The Kroger brought in attorneys from all over this state. They brought in attorneys from Ohio. They had all kinds of people. They did everything they could, every dirty trick in the book.
Even a shadow jury.
Yeah, they had a shadow jury. We'll talk about that in the trial portion. But let's start at the beginning. So Tyler, why you really took this case. Obviously, we work as a team, but you really primarily handled this case when it came in the door until we got up to the trial when we worked on it more closely together. But what really motivated you on this case?
Brian. I got to meet Brian, and when he came in, talking with him, I mean, you could tell right off the bat. I mean, he was a great guy, great person, great family, and I mean, his injuries were just so terrible. Mm-hmm. And I'll never forget when.
Let's show pictures real quick of Brian's hands. You can see here. This is his hands currently. Go ahead.
I'll never forget when Brian first came into the office. We were talking. And he said, "Are you sure you want this case?" I said, "Yeah, I'm sure." He's like, "I've talked to other attorneys. They tell me there's nothing here. Are you sure you want to take this?" And I said, "Absolutely." That was early at that point, right? I had just met Brian. He just told me what happened. And I told him, I said, "We'll find a way. Just let us do the work." And, even recently when we saw Brian, he always talks about that. He's like, "I remember when we first met and I was telling you, like, are you sure you want this?" And he's like, "Now we're here."
Yeah, it's amazing to me how a lot of the biggest verdicts that I've gotten have been on cases where there's been a wonderful human being of a client who really nobody would help. Mm-hmm. I mean, the first 8-figure verdict that I got was a race discrimination case where 3 other firms had turned down the case. I didn't understand it. I didn't understand in this case, it was a clear case to me from day one. I mean, it was, wait a minute, you took a cap off a pipe. Now, we didn't know shit about pipes and refrigeration systems and how they're supposed to work. So we weren't sure about the mechanics of it, but it seemed to me like pretty straightforward. Wait a minute. Is it supposed to explode when you take the cap off? Mm-hmm. No.
Right. And the other thing too is Brian was experienced, very experienced, and he'd never had anything even close to this ever happen before. So that's your first red flag.
Yeah.
Sometimes he's
not a sloppy guy. It's
right.
not like he was like doing something outside the scope. This is what he was trained to do. He'd
done this specific thing a million times before.
Yeah.
It wasn't anything new to him.
So what challenges when you sued Kroger, what were your objectives and challenges in working up the case?
They didn't want to produce anything. They consistently said, we don't have this, or sometimes they'd say we have this. And then, when push came to shove, be like, that was a mistake. We actually don't. We'll talk more about this, but there were cameras all over that store. No footage.
All the video footage. You got a guy whose hands got blown off in the middle of the day in your store, and there's a toxic gas cloud. And Kroger wants us to believe that there's no video footage of that? Come on.
No incident reports. They did have one kind of incident report. It's partially filled out.
A year later.
They filled it out a year later. Right?
Suspicious.
Suspicious. No video.
Now, what about, did you ask for maintenance records? So, I mean, we're alleging, and we allege, and it is now a fact, that Kroger had this dangerous condition that they should have known about and that they just ignored. Either they knew it was there and they didn't care, they didn't warn, or they created it. So did you ask for maintenance records?
Absolutely. Any part, a very important part of any premise case for lawyers is you got to show that somebody knew about it, right? Or they at least should have known about it. So in any premise case, you ask, tell us how you inspect these things. Do you keep logs? Do you make records? And never gave us anything. Nothing.
No maintenance. So, I mean, does anyone out there really believe that one of the I think it's the largest grocery retailer in the United States of America would not keep any records of the maintenance? And this store had been around for like decades.
I think since the 60s.
Well, and to your point, is they had a whole team dedicated to working on these refrigerator systems. It wasn't like they actually had a department within the corporation that did this.
Yeah, they had a refrigeration department.
Right. So how do you not have records when you have a department specifically for that?
They said, so they told you, we don't have any maintenance records. Did you take them to court for that?
We did. We filed motions. We got orders from the judge saying, look, you got it. If you got these, you got to cough them up. They never did.
I think that was one of the most important things that will tie in later for trial was you pushed it, okay? You know, if you would have said, and so many lawyers I see say, well, I asked for it, they didn't give it to me, let's just
move on.
Let's just move on, or, you know, let's not really push it. That's disastrous because then they can produce them later, make it up, you know, say that they never asked for it. So you really have to push the ball forward.
Absolutely.
So no incident report, no maintenance records. So, I mean, was that challenging, right? You have a case where we're saying, hey, there was something wrong with your refrigerator that caused an injury, and they don't give you any of the information?
It was challenging, and it was a little bizarre. You know, they claim nobody saw this. No, they claim they didn't even know about it.
Yeah,
You
right.
know, there's an explosion on their store floor. There's people in the store.
Yeah.
They have a man
It
who
shut down the whole freezers for this whole store. All the turkeys thawed.
you know, and they claimed they didn't know how the system got started back up. They just claimed they didn't know anything. Like, we didn't know this happened. So it must have been Brian's fault.
Yeah.
That was their story.
And then one thing that I think we should point out too to our viewers is, look, if you're not a lawyer, when you sue a corporation, they have all the information, right? Like, we can't just go into Kroger and start rifling through their documents and pulling out what we want. So legally, we have to ask for the information that we need, and then they legally have to provide it. So did you ask for, hey, tell us who the manager of the store was who's responsible for maintaining, inspecting, doing all this stuff?
Right, and that's where it gets even more bizarre because we asked for that, and they gave us a guy. So I drive all the way out to Bloomfield, go into the defense attorney's office. This guy's sitting there.
Great guy, by the way.
Great guy.
Like
Turned out-
the only honest Kroger guy, in my opinion, in the whole case.
I sat down with him, and the only thing I knew about him at that point was he had signed this incident report that
was done a year later.
drafted a year after the incident. That's all I knew about him. And I knew that they were producing him as their guy who knew the most about the maintenance of the system.
They told you, right, that this was the guy who's in charge of maintenance. This is the guy who's in charge of inspections.
Right.
This is the guy who's the guy. This is the guy, Marko Law, who we are going to put up as our guy.
And he had knowledge of the incident.
And knowledge of the incident.
Yeah, we didn't pick him.
Yeah.
Kroger did. They said, this is the guy that knows. And so I sit down and I start talking to him, and he didn't know anything. And
What do you mean he didn't know anything?
He didn't know anything. He said, you know what? I wasn't even the manager at that store when this happened.
So why would Kroger tell you this is the guy to talk to about all this information when the guy didn't know nothing about nothing?
That's a great question. He said, I don't even remember signing that incident report. And I showed it to him. He said, that is my writing. That's me, but I don't remember doing it.
Somebody told him to do it.
Yeah. Didn't he get like a phone? Didn't he get a phone call or something? And someone was like,
he was I told the jury, he was the patsy, the fall guy. Right. They put up this nice guy who didn't know nothing. And you know who hides evidence and who runs away from having to testify? Criminals.
People that have something to hide.
Right.
Yeah.
So did you do, one of the biggest things? So was this challenging, right? Because you're like trying to get information to build a case. We build a case by getting information. Was it challenging that like Kroger was just not providing any information to because we hired an expert witness, right? On refrigeration. And he's asking us, give me information so I can tell you what did or did not go wrong. Was it challenging that you're doing all this work and they're just saying, yeah, we don't have any information about anything?
It's really challenging. And we had to get Kroger's inspection, their manuals, their safety protocols through our expert.
So let's break that down for our viewers. All right. So did you ask Kroger through a lawful request in the case, did you say, hey, Give us your policies and procedures on how do you inspect these refrigerators? How do you maintain these refrigerators? What are your rules? What are your policies? Where is the data stored? What do you have to do? Did you ask Kroger for that?
We did. We call them interrogatories and request to produce. And we said, give us everything you have, all your materials regarding the maintenance, inspection of these systems.
Including like their policies.
Their manuals,
and Kroger has
their
policies for everything, right?
Right.
I mean, they got like thousands of policies. So did they give you the policies?
Nope. They didn't give it to us.
What did they say?
They said, upon diligent search, fancy lawyer language, right? We can't find any of the requested
We don't have any
documents.
policies.
We don't have it.
That's a bunch of bullshit.
But
right?
we know it
We know
because
that
our
now.
expert was able to find it.
So we tell our expert, hey, they say there's no policies. And what does he say?
Are you sure? Because I got something from, whether he got it like a year ago or something. I don't know how, but he was able to hunt it down.
So our own expert produced Kroger's policies that they had hidden, unlawfully hidden from us.
Mm-hmm.
I mean, it's crazy. I've never seen something like this. And it's really not how trials are supposed to go. There's search for the truth. There's usually good evidence and bad evidence and everywhere in between on both sides. But you're supposed to lay all your chips on the table.
Yeah.
Do you feel like Kroger did that in this case and their attorneys?
Did what they were supposed to do?
Yeah.
No. And what's bizarre is I've handled a lot of premise cases. And, if, let's say I asked for these schedules, these inspection reports, if they got them, they can't get them to me quick enough because they're going to say, here's proof that we did what we were supposed to.
Right. Like we mopped the floor,
Exactly.
Look, here's the log. Mr. Smith, the janitor, mops the floor every 15 minutes. Here it is.
Sometimes I don't even have to ask for them. I'll get them in initial disclosures. Here are our maintenance records. We were checking. We did what we were supposed to.
Yeah.
And everything suddenly disappeared in this case. Where
Everything.
there's a guy who's literally had his hands blown off.
Isn't it true they didn't even have the scope of work? We had to get that from Brian's employer.
Right.
Yeah.
So
Like they didn't even have their own paperwork from the job.
Right.
Yeah. So we asked for the paperwork from the job. Did they produce that?
They didn't. We had to send a subpoena to Brian's employer.
Yeah.
And they sent us all that information.
And it was really important, Tyler, that you did all this because that showed that Kroger was supposed to do before Brian Mierendorf was sent there to work on this dangerous system. What was Kroger supposed to do under that contract?
Right. Yeah. Kroger's big argument all along was, hey, you know what? We didn't have anything to do with any of this. We hired this entity to come in and do all this work. We didn't have anything to do with anything.
It's not our problem.
Yeah. And
they compared it to a roofer.
right.
They told the jury, hey, if you hire someone to work on your roof and that person falls off your roof and sues you, do you think that would be fair? Remember?
yeah,
that's
which was
literally what
not
they said.
a true analogy.
Right.
And we found that out through the scope of work where it specifically said Kroger was supposed to do pre-project, pre-inspections, check all the valves, the seals, all these little details. That was Kroger's responsibility. And so that blew their argument right out of the water
The contract said literally before your worker, Brian, starts to work on this dangerous system, we promise we're going to inspect every piece of it to make sure that it doesn't hurt anybody and that it's working.
Right.
Mm-hmm.
Did they do that?
They sure didn't provide any proof that they did.
Mm-hmm.
They did. Yeah, it was really bizarre. I mean, it was bizarre. I mean, you think of words like cover up and, this was very serious. What's sad to me too is this guy's life's hanging in the balance. I mean, he's suffering. He's never going to work again. He can't support his family. And Kroger is either losing or disappearing all this key evidence. It was very bizarre. And
Absolutely.
I think that's important because I think people understand why would someone delete, hide, or withhold evidence?
Because it's not good for them.
Right. Now, did you go? One thing that I've talked about that I think is important that we don't do enough of, especially on big cases like this, is you go to the scene.
Mm-hmm.
You go to the scene of the crime, right? So to speak. You want, we can look at a million pictures. And by the way, Kroger gets to take the pictures and give them to us, right?
Right.
So they can take them from the angles they want and all that stuff. But you go to the scene and it's amazing what you will pick up on the little things. Did you go to the scene?
We did. And at that point, they had put the cooler back together. It was all covered. So we really couldn't get into the details of what happened in the cooler. But what was really important was as soon as you walk up, you see all these globe cameras. One right above the cooler, another just off to the left, another just over there. All of these cameras all over the store floor. So
yeah, and if anybody goes to a Kroger, look up. There's little black domes all over the place because they don't want people stuffing turkeys down their pants and walking out the front door, right?
Right.
They literally have their asset protection people monitoring this stuff. Yeah. Or if somebody gets hurt and sues them, they can say, sir, you didn't slip on no banana peel. You had a bad flip-flop on or whatever it is.
Right.
And look at the video, right? Mm-hmm. And they always have video.
And
They're supposed to.
And then this ties into the incident report, where we'll talk about this more too, but they only produced one page. And on one of the pages they didn't produce, it says, after an incident, you got to secure all that footage. Even if it doesn't show anything, even if you see a customer leaving or coming, you got to lock it all down. And that was one of
lock down all the footage.
Yeah.
So then you can say, look, here's all of our cameras. Here's all the footage. There's nothing to be seen. Let's show a picture of that globe camera right now so they can see. Tyler, did you take this picture yourself?
I did.
On the scene?
When we were there.
And then we get to use this as evidence in the case.
Right.
Yeah.
And to John's point about the cameras, one of the, I think, key things in the trial was talking about, like, it wasn't just that camera that captured him. He was running through the store. So where's the rest of the footage from him running through the store, up the ladders, out to go to the hospital? All of that's gone. Every camera that traced his pathway that day is
right.
You know what I'm saying?
That was another big part of the scene inspection is we were able to retrace Brian. And I didn't understand this when I had talked to him before, but how far he had to go to shut down this system. And he had to...
and let's show this. So let's show this picture. This is the ladder. Did you take this picture of this ladder? Look at, there's like beer and shit all around it. How are you even supposed to get up there?
Right. So he had to get off the store floor, go into a back room, climb a pretty tall ladder, probably 20 feet.
How did he climb a ladder with his hands halfway blown off?
With his elbows.
Horrible.
In the middle of winter.
In the middle of winter. And then he gets onto the roof, and there's multiple levels to the roof. So he's got to move across the lower roof.
Let's show the roof. Look at this, guys. This is crazy.
And then you can see in the picture there's a smaller ladder that gets him onto the second level.
So he has to climb up another ladder with his elbows?
Right. And this is February in Michigan. Yeah. So there's snow and ice all over this roof. Can't use his hands. He's got to run to this complicated series of pipes. This is the best
part.
And Brian
tells me, is it like, do you have a circuit breaker in your basement to like turn off the power? Can you just like pull the switch down and it shuts off all the coolant flowing through that was spraying out in the store?
You can't. And what Brian encountered was like if you were in someone else's house and had to turn off a single circuit breaker and you ran to the box and nothing was labeled.
Nothing was labeled.
That's what Brian had to deal with. So he starts turning off these circuits
with a wrench,
with between his wrists, his
and
elbows.
His hands are like literally like dying from this toxic refrigerant.
Well, yeah, the thermal burn. His hands are getting cold. He can't feel them. He can't use them. So he's got
a nightmare.
It absolutely is.
Horrific.
And then Kroger's, this box on the roof was like 40 years old or something, and was all mislabeled. So he had to shut down the whole system by taking a wrench to each and every single little thing, like
and
on the
hoping
circuit
it was
breaker.
it.
Right.
Yeah.
I mean, so one thing that your scene inspection, and I went a couple days before trial, we were driving out to court, and I stopped at that Kroger and bought a coffee and just looked around myself. Now, I couldn't climb up on the roof and stuff because that was, not accessible, but just to get an idea, breathe it in. Put myself, what did Brian go through? What did he see? Because you pick up on a lot of little things. Like, for example, Kroger said, well, nobody saw this. Well, there's people all around. There's a meat counter right there where there's dudes slicing deli meat all day long, right? And the other thing is, what do you mean? There was toxic refrigerant sprayed all over all of your food in like this huge radius. Did you just sell that food to people? I mean, this stuff is so toxic. When it's released, you have to report it to the EPA or you can go to jail.
like a cloud. How did you not notice?
Right. There's a thunderstorm in the middle of your store. How did you not notice?
Right.
So that was very helpful. And now getting, before we switch and have Mr. Eads come on, Jon Eads, and talk about some of the things about the trial, like leading up to the trial, it's a lot of work, isn't it?
It's a lot. The 2-3 months before a trial is the most work you're really going to do, even probably more than the trial.
I
probably agree.
Yeah.
The
and
prep
it sucks because it's like tedious,
right,
monotonous, motions.
And you don't know, is the trial going to get adjourned? Could the case settle? Now, in this trial, we knew that the case was probably not going to settle just based upon what Kroger had said. But you don't know. You're doing all this work. You're moving up on this date. And, you know, I'm sure you've had it. You show up for trial and the judge says you're adjourned. You just don't know. You don't know if it's going to go. So you're doing all this work.
Well, and then that's a good point. We did all this work. We got ready for trial. And then the court, who's a wonderful human being and judge, Judge Jacob Cunningham in Oakland County, very smart young man, but had a criminal trial.
Yeah.
And so he emails all of us. We wanted to go forward with the trial.
Mm-hmm.
Like, we're ready to go. We have all of our witnesses ready. And the defense doesn't want to go. They love to delay. And the court emails us and says, I'm sorry, we have a criminal trial, right?
Mm-hmm.
And canceled our trial. 2 days later, says that case is done, settled, or
You're
resolved. You're back on.
We're starting Thursday. And that was great. What do you think?
That was a roller coaster. You know, you're upset because the trial's adjourned. You put in all this work, and
your client's upset.
And so, you know, we're down. I'm sure the defense was happy. They were probably dancing. They probably went out to the bar. We got an adjournment. We can kick this down the road longer. And then 2 days later, bam, complete 180. We're back on. You know, and I remember the defense was really upset about that.
Yeah. Now tell our listeners this dirty tactic that they did the night before the trial. So we're getting all ready for trial. You know, it's a lot of work for a trial, a big catastrophic case like this. I mean, I'm driving around, you're driving around, Jon Eads is driving around the state. We're taking doctors' depositions in Ann Arbor. I was staying at U of M. I was at Mott Hospital almost every day, doing all this stuff at University of Michigan Hospital. And you're ready. You think you have everything prepared the best that you can. You're never feel 100% ready, no matter how much you do. Mm-hmm. What did they do? Literally the night before trial, at like 12:01 in the morning. The
notorious 12:01 document dump is what it came to be known throughout the trial. And we get it was a link because there were so many documents. We got emailed a link at 12:01. 12:04, whatever it was, and we clicked the link, and it's thousands of pages of just documents that we'd never seen before.
Oh, it was crazy.
Never
videos, not of the incident, but they went and had a secret recreation of the thing with videos of people we didn't even know about, alleging that they turned this. I mean, all kinds of crazy shit, wasn't it?
Yeah, they had made a video where they tore open that cooler and they had somebody, we don't know who, in there doing work on it, showing how this could have never happened, like we said it happened, trying to do a recreation.
Which is entirely inappropriate.
Right.
Because they could do whatever they want, manipulate. Remember, this is a company that up to this point in the trial had hidden policies and procedures. Hidden, deleted, or allowed to be destroyed video, done all the other stuff. And now they suddenly have the night before trial, a recreation that they wanted to show the jury of mystery people who we can't even call. We have a right in litigation to confront and to ask questions, to cross-examine, right?
Yeah.
And you can't do that. It's like, oh, this is a mystery person somewhere who did that. I mean, come on.
Right. And we didn't even know, was it the same cooler? It was clearly a different system because their system had been revamped
modified.
At that point.
It wasn't even the same pipes.
Not the same pipes. We didn't know the pressure. We didn't know the materials, the caps, and we knew nothing. And they wanted to show this to the jury to say, look, this couldn't have happened like they say it happened.
Yeah.
Yeah.
Oh, and we have 2 new witnesses that we've never disclosed, never said their name. We want them to testify too.
Yeah. After they had told us, these are the people that know about this incident. It was very bizarre and very disappointing that a defense, given what they did to this poor man and his family, would take to this dirty tactics. I call them dirty tactics. But if we as plaintiffs' lawyers would dump thousands of pages of new secret materials the night before a trial, I mean, this case had been pending for 2 years.
Yeah. To your point, they mentioned during the trial, it kept coming up about the 1201 document. Our client had just had a surgery the week prior, and they tried to associate us telling them that there were new surgery records to their document dump. Like insanity.
No, it was insanity. And it was like weird documents too, like maintenance records of other coolers that weren't even the cooler at issue. It was a lot of smoke and mirrors, I like to say, to try to confuse the jury, to try to trick people. And even if it didn't work, it still worked because we had to go through our team.
Hours.
Thousands of pages of documents because we didn't know what the judge was going to do. Maybe he lets them in, probably not, but maybe.
Yeah.
What's in there? Is there stuff in there that it was very disappointing.
Yeah. Day before trial.
Right.
Well, you did a great job on
Thanks, John.
working that case up and then going to trial. It was a tremendous amount of work. We needed a team. It takes a village, they say. So thank you for your work. Let's have Jon come in and talk about some of the challenges that we did at trial. All right, welcome, Johnny. It's back on the show.
Hey, good to see everybody.
Good to
nice
see
to
you.
see you.
Good to see you.
Samantha, Tyler, pushing over the 50-yard line, right? And here we are.
So what did you think when you got involved in this case late, right? You had maybe just joined the firm at a month or so?
Yeah, so I joined the Marko Law as a managing partner in the beginning of March, and I had picked up a case in April, which I had tried in the same courthouse, but down the hall in front of Judge Martha Anderson. And so we were trying to figure out what we were going to do with Mierendorf because it was such a rush to the courthouse. And Tyler and you and I sat down and tried to figure out a strategy moving forward for how we were going to approach this. And so my first task was to learn about the case because there wasn't a lot. Tyler did a great job working with brother counsel in other law firms who had handled other cases against Kroger to come up with, I thought, was the smoking gun in the case. And that was an incident report form that was actually 5 pages. We had only been given a 1-page incident report. And that incident report involving the other 4 missing pages was gold.
Yeah. So just so they understand, Kroger produced, in our case, a single page. They said, this is the only incident report that we have. And by the way, guys, there's incident reports for everything. Okay, you go to a bar and you fall and you get hurt, and especially if it's serious, they're going to fill out some type of report.
Yeah.
Kroger especially.
You drop spaghetti noodles in the aisle and they're going to fill out an
incident report. Yeah, and that was the incident report. It was
Right.
just spaghetti noodle. Some lady fell on spaghetti noodles. We got it, I think, from, was it Scott Goodwin, who's our friend and great attorney. He said, hey, I have a Kroger case, dude. And Tyler had talked to him and tracked this down. And your incident report should be like 6 pages.
Yeah.
Right?
Yes.
And it was very important. And we'll talk about that. But let's talk about jury. First of all, before we get to jury selection, we split this case up. So talk about, have you seen a lot of other firms do this? Because I think this is genius level litigation.
And Jon Marko is such a savant. He came up with this idea of trying to bifurcate this into 2 cases, securing 2 voir dires, securing 2 openings, securing separate questioning of witnesses. And so where this brainstorm idea came up is when we were doing a pretrial sort of prep session with the Mierendorfs. And Tyler and you and I had a sort of a sit down, and we were trying to figure out how are we going to do this.
And the wife had her own perspective. Remember, the wife wasn't there, but she was suffering the effects of this every day. I mean, she had went from a stay-at-home mom to essentially a caretaker for her husband and having to go back to work full time.
Right.
She had her own story. It was almost a different story.
She was
did.
mom and dad.
She did. Yeah. And I don't think that Heather was deposed during the case. And so when what I was tasked to do, and Tyler obviously did a phenomenal job and had such a great relationship with Brian, I was selected to do a mock cross-examination of Brian. And during that cross-examination, Brian said, I can't do this. I can't do it. And Heather appeared on the scene for the first time, and I got a chance to spend some time with Heather. And I was so taken with her patience,
Wonderful human being,
with her love, with her commitment, with her taking on a new job where she would have to leave before her their two young children would even get out of bed.
Hey, she worked for the Department of Defense.
And so I was so taken with her. And when you brainstormed having these two separate cases, Tyler and I kind of made a decision that we really need to emphasize her part of the case. Because
She had her own story.
She did. She had her own story. I mean, she had been at U of M hospital for several months, living out of a suitcase in a hotel adjacent to the hospital during COVID, where she had no contact with really other families.
Yeah.
And she had to do this on her own. And then she would go back to her room after being there for over 12, 13 hours a day and start doing her work for the doctor that she worked for after she had been helping Brian all day.
I mean, I don't know. What happened to Brian was the greatest tragedy, but he is so lucky that he had Heather. And as good lawyers, we had to discover this, right? Because these are people, these are clients, we're busy. But I cannot emphasize the things that you pick up on spending time with your clients. We took Heather and Brian out to lunch before the trial. We went out to, where was it? Joe
Italian
Miller's or
restaurant.
something? or
Cooper's Hawk.
Cooper?
No.
No.
It was Andiamo's.
Andiamo's at the mall.
Yeah, right. At the Partridge Creek Mall.
Right.
Yeah,
That's right.
We went there.
And you get to pick up on these little things that you really, and this came in for my closing. I think this was probably the best closing argument, in my opinion, I've given, or it's up there. But it didn't come through just Jon Marko being a genius or Jon Marko being the best lawyer. It came from spending the time to get to know and care about the clients. The little things that you can pick up on. For example, when we went to lunch, Brian sat with his back towards everybody in the corner of the restaurant. He picked a corner table and he kept his hands underneath the table except when absolutely necessary. I noticed that.
Yeah.
Okay. Brian, when the waitress would come around, he would put his hands back under the table because he was ashamed of his essentially, deformed hands. Brian, Heather would help
Cut
Brian.
his
He would
food.
drop things. She would help. She cut his steak
Yeah.
at the lunch. And it's it's almost embarrassing. This is a guy who was, the family man, the head of the family who's going through this. But part of it is caring about people but getting to know them, because that helps us tell their true story at trial. And I think it comes across. We know we care about them. And for people that don't understand, loss of consortium is a legal theory that allows the wife or husband or partner of somebody who's been married who gets hurt to file their own legal lawsuit claim. So you want to talk about that?
I do. And integral in this process was Samantha Teal. Samantha had the contact with Paige Alderman, who was a fellow hockey mom. She had the contact with Dr. Kraft. She had the contact with Patricia Fortier, who was the mother of Heather. And we were painting the picture of Heather as a person from her birth, her growth as a human being, her high school experience, her meeting Brian by chance at a graduation party. And Samantha set the table for us to be able to tell a story. And Heather was such a wonderful person. By the end of the trial, the foreperson on this jury blew Heather a kiss as she walked out of the box because they were so taken with how this had impacted Heather.
Mm-hmm.
The loss of affection, of love, of the relationship, little things that Heather and Brian had done together, like Brian bringing Heather a coffee in the morning from a store that she really liked.
He couldn't do that anymore.
He couldn't do that because he couldn't even grab a cup through the drive-thru or lift a cup and bring it to the car, and not being able to handwrite a love note or a note just to say, "Hey, Heather, under your windshield, wiper, have a great day." And then what happened to the wedding ring that was on his left hand?
Can't wear that ever again.
He never wore it
Wore it again.
And these are the types of things that Heather, as a human being, had to endure, and the loss of the person who she married, in a lot of symbolic ways, was so moving to the jury when we presented that evidence.
But so our listeners understand who aren't lawyers, you have a right in Michigan, as in most places, if you're the spouse, to actually bring your own claim. Now, a lot of times jurors look at these very skeptically because they're saying, all right, look, I get Brian Mierendorf had a serious injury. I don't have philosophical problems with a verdict for him for what was taken away. But I just think that his wife now, who wasn't there, who is not involved and not directly physically injured, I think that's just too much. That's just too much. And we had some jurors say that. And so traditionally, but the law says they have a right to a claim. But traditionally, jurors, I think, are reluctant in general or more conservative in giving a spouse money because they're just like, it's too much. It's a bridge too far.
Yeah, let me make a quick point about that. I've had cases that I know of cases where insurance adjusters, where it's an injury to a child, tell a parent, we're not going to pay you anything. It's your obligation. It's a responsibility you took on in life to take care of your child. Why would you want to be compensated for that? I've had situations where we had a potential juror say, I just don't believe in that philosophically, and I'm not going to do it. I know as a defense lawyer for 35 years, my first question to a spouse under these circumstances would be, do you love your spouse any less? You don't, do you? And so why do they deserve separate money when the money's going to be already going to the injured person?
Which is going to benefit the family.
Sure.
Yeah.
And so that calculus was something that we really had to think about when we were preparing for trial. And I think as a team, with Samantha bringing her perspective, Tyler bringing his perspective, and then you and I having our experience in the courtroom trying so many cases over the years, we made this into two people.
And so what my idea was, and you're legally allowed to do it, but a lot of people don't know that, and a lot of people don't do it. So the norm is when you have a wife and a husband, the same lawyer just represents both of them. Hi, I'm Jon Marko. I represent the Mierendorf family. I'm going to be presenting a claim for Brian and for Heather. That's the norm.
Yes,
that's what 99.9% of other lawyers will do. Now, I had an idea, and we researched it, and it's legally sound, and they do it in other places. And I wish I could take credit, but I had picked up this idea from, Nick Rowley and some of my great trial friends out west, that when they have a loss of consortium claim, they'll split the claims. One lawyer will represent the husband, one lawyer will represent the wife. It's good in a lot of reasons. It allows a separate lawyer, as you explained, but it also, you focus on the wife's story and I focus on Brian's story. And it also insulates us if we get a juror that says, I think that's greedy, that we're going for the wife too. That's not me. I represent Brian. So it allowed us to kind of have a unique role in the trial. You focused on the Heather role. I focused on Brian. And it didn't really prolong the trial. I know a lot of judges, I think we told the judge, look, we're not going to repeat stuff.
Yeah.
Mr. Eads is just going to be doing his role and I'm going to be doing my role.
To your point, I think it was most impactful, at least from my perspective, sitting there during voir dire, because you were able to focus on the liability and the damages, and then he was able to come in and focus on that portion of the case and people's feelings towards awarding money for those types of cases. So it was perfect because you were able to do what you need to do and he was able to do what he needed to do so that we could find an unbiased jury. And really, that the claim that we brought and he was representing was really key in like who ended up being on the jury.
It really was, and let me say that the person who ended up being the foreperson was selected because of a critical mistake by the jury consultant retained by the defense.
Yeah, let's talk a little bit about that. So we get jury selection. For our listeners who aren't lawyers, each side in a civil case gets to take off 3 jurors. Each side gets to pick 3 who they don't want for whatever reason other than race or gender. But whatever reason, you get to say, you're gone, you're gone, you're gone. We each get 3 strikes.
Mm-hmm.
This was a hotly contested jury selection. You can also get jurors off for what's called cause. Like a juror gets up there and says, Judge, I work at Kroger right now. I cannot be fair.
Mm-hmm.
Now they're off and you don't have to use your strike. There was a lot of jurors. This was very difficult jury selection.
All day.
Because we ended up using all 3 of our strikes. They ended up using all 3 of their strikes. There was people who I thought should have been dismissed without me having to use a strike. So for example, there was this crazy lady who used to do loss prevention analysis for Kroger.
Yeah.
Her brother-in-law was on the board of directors for the Kroger Company of Michigan, a Michigan corporation. It was insane. Now, obviously, the problem was I talked to her and she's like, well, I think even though despite all this, I could be fair. And people were almost like laughing. It was so freaking laughable that this lady, I said, ma'am, I'm going to be asking for tens of millions of dollars. So you're going to, at Christmas dinner with your brother-in-law who's on the board of directors and getting all of that money from Kroger Corporation, what are you going to tell him? If he, she's like, oh, I just wouldn't bring it up. I just would keep it from him. I'm like, give me a break. Now the judge, said no, and very good judge, but I disagreed with him on that. He said, no, you have to use a strike. So we did.
Yeah.
We had a doctor who hated me and said, I hate plaintiffs' lawyers. I said, what do you think about me? She's like, well, you're just doing what you have to do. Remember?
Yeah, she was.
I do.
She didn't like either that we brought a consortium claim.
Right.
No,
right.
we had to strike her. And then Kroger had a bunch of lame stuff going on. But we did this voir dire, and I think we could talk about voir dire all day, the selection of the jury. But I'd like to talk about 2 very specific things. Number 1 is following your instincts in voir dire. So you guys are all very experienced. And I value the input of my entire trial team.
Mm-hmm.
There was one juror who ended up being I'd say vice chairperson, although he wasn't, but he was a very nice guy.
Yeah.
Very intelligent guy. He's a former Navy guy, but very serious. And on paper, if you follow if you're picking a jury based on paper, we generally the general consensus would be we want more progressive minded as opposed to fiscally conservative or politically conservative, tort reform people. I mean, there's just certain things that you look for. And so my team, you guys, were very concerned about this guy. He was Navy guy, very rule bound, right? He was he's a religious guy. He's a good Catholic guy like me. He was skeptical of lawsuits. He told you, John Eads, I think that he didn't think that it was fair for lots of consortium claims.
Yeah. And damages. He had a hard time, I believe he said, awarding over $10 million, if I recall correctly.
Yeah. So on paper, if you're just looking at the facts, just the data, popular sentiment would be you should use a strike on him, right?
I think Samantha and I both agreed that he's not somebody we want in the jury. I was thinking about, look, if we agree to 6 out of 8, okay, he'll be a holdover maybe. And as long as we get 6, we're fine.
Yeah.
There were a lot of different things that were going through our mind with regard to this particular juror.
Yeah. And picking a jury's hard. The one thing I've learned over the years that's most important is follow my gut.
Mm-hmm.
Not that it's always right, but it's mostly right. And
For
so
sure.
I talked to this guy, and I liked something about him. I don't know. We had a connection in a way. And he gave those bad answers on paper, but I remember him saying, I think that's too much money. You know, you're asking for tens of millions. I think that's crazy. I said, well, let me ask you something, sir. What's the most important thing in your life? He said, my children. I said, what if some company took your children away from you, or some person took your children away from you? How much would that be worth to you? And he looked at me, and it wasn't a reaction of, it was a reaction of honest, I see what you're saying. Okay? It was an honest thing. He didn't need to say that, but he said, you know, something to the effect of, you know, I understand your point or something. And it wasn't like a fight, but it was an honest discussion. And I don't know, something in my gut said, I think he's going to be okay. I think he's going to be fair. I always like jurors that can evaluate their own selves and realize that they're not perfect. Jurors that say, oh, I can be fair no matter what. I hate, yes, my brother-in-law works for Kroger, but no worries. I'm just going to hide it from him. Okay, she's not going to be fair. Get the hell off my jury.
Yeah.
And this guy was a great advocate.
To your point too, he was very like, you know, you talked about responsibility and following rules, and he was a rule follower. And I think in the back of your mind, you know, when you had said this to us, to John and I, is you knew what was coming in terms of what Kroger was or wasn't going to produce. And you knew that with the integrity that this man had, and having been in the Navy and fought for our country, he understood the concept of being honest.
I think that I thought he would, as the trial went on, if things went well, come around.
Yeah.
And even though he had certain views, and he was great, and he's a great guy, and I thank him, and I'm glad that I didn't listen to you guys and that I kept him on the jury.
Yeah. But you didn't listen to us either.
Absolutely. And I knew that it was going to play in also with some of the medical experts that we had that had Gulf War experience doing surgery. I knew that ultimately, once I processed it a little bit more, may help us, because he saw action.
Yeah.
And he saw what these field surgeons have to do for his brothers and sisters. I think he was a corpsman
or something.
Yeah.
Yes.
Now, the other, let's talk about the big mistake that you said. And this we all saw happen in real time. And just so our listeners know, Kroger Corporation had over $200 million of insurance. So people that are like, oh, it's their own insurance or it's their own money. No, it's not. Okay, your grocery prices ain't going up from this. They had a $215 million of insurance, and they spared no expense in doing everything they could to prevent the Mirandor family from getting any justice in Oakland County. They hired probably, how many lawyers did they have over the case? 8, 9, 10?
There was at least 5 sitting there every day.
They had 4 different law firms. They had an appellate firm. They brought in a firm from Cleveland, Ohio. They flew the guy in. They had a big local firm that had a team of lawyers on it. They had, it was absurd.
It was packed.
They had in-house.
They hired a shadow jury that was different from the jury that was in the box, who were being ushered around by another company, and they were asking for input at lunchtime and then after the conclusion of each day's worth of trial.
What was interesting is this shadow jury, and I had never seen it in action. I've read about it. Have you ever seen it before, this thing?
I have. And obviously we do on the defense, when I was in the defense side, exactly what you do. The case that I tried was going to try in Wisconsin about 2 months before I joined. We had all traveled to Wisconsin, and we had an all-day, 3 separate jury mock trial. And from that mock trial, we would have selected a set of shadow jurors because they would have been familiar with the case already, to actually sit through the trial. And
wow.
We ultimately resolved the case on behalf of a Fortune 500 company after that mock trial during a mediation.
Well, so just so our listeners understand, I don't know if you've ever seen Runaway Jury with Gene Hackman.
Oh, many times.
Where they have like this secret war room and they're doing all this, devious shit with these jurors and stuff.
Yeah, and they're following John Cusack around.
Right.
Who's on the, one of the jurors.
So our listeners understand, I'm not used to a shadow jury, and the judge had never seen it. I don't think many people have. Had you ever seen it, Samantha?
No, not in 10 years of working. I was with Jeff for 8 years and traveled all over the country on huge cases and never once saw it.
So there was these people that there was about 8 to 10 people that kept entering the room every day when the real jury entered the room.
Yeah.
And look, I'm used to people come and watch our trials. Other lawyers want to come and see our trials. They think, we're known as the best trial firm in the state of Michigan and in the Midwest. So I'm used to other lawyers coming to watch us. I'm used to people in the community who say, Marko Law's trying a case. They want to come and they want to watch and they want to learn and they want to see. So I'm used to that. So at first I wasn't surprised that the gallery was full of people, but day in and day out, it became strange. Who are these people that keep walking in at the exact time that the jury walks in and they sit in the gallery and then they walk out? And I think one of you figured out these are people who have been hired by Kroger Corporation to watch the trial and then issue secret reports to Kroger each day on the trial so that the Kroger attorneys could try to use it against us, right?
Yeah, so in the age of nuclear verdicts, the Tower of Insurance makes decisions collectively on how they can properly evaluate damages and how testimony's coming in. So what happens is they locate through online surveys individuals who will agree to do this for a daily amount and then expenses. And then in exchange, these individuals who are paid will give analysis on multiple questions, both at lunch and then also after the conclusion of the trial day, so that data can be processed amongst a whole host of individuals interested in the matter.
Yeah.
And so that's typically how it works.
Now, my understanding is these people didn't even know they were working for Kroger Corporation.
No. Well,
right? Or
the other thing too is something I noticed was the demographics matched our jury.
Yeah, so like
that was how I kind of figured it out.
So there was like an Indian person on our jury.
Yeah.
So they had an Indian person on the shadow jury.
Yeah.
There was like an old white dude on the jury. They had an old white dude on the shadow jury, right?
It
Correct.
matched the demographics of what our jury was.
And it's very powerful because as folks know, when you're battling a corporation with unlimited funds, with unlimited insurance, it creates this
David versus Goliath.
Phalanx story, David versus Goliath. Exactly.
Yeah, and what was interesting was that these jurors didn't know that they were secretly working for Kroger.
Yeah.
And it was quite disruptive because they came in and out, but we researched it because I wanted to keep them out of the room because they're feeding secret information to Kroger about do this or do that or whatever, not even knowing it, right? Mm-hmm. Like saying like this piece of evidence is powerful, this isn't. But we did some research, and the research that we found was we were not legally able to keep out a shadow jury because courtrooms are open to the public. As long as they didn't interfere with the trial, they're allowed to have observers that are reporting to them, right? Mm-hmm. So
correct.
We did research. So I think the judge found it odd. And you know what was really, they're spending all this money to try to ruin the Mirendorfs when they could have just done the right thing.
Yeah.
Yeah, it was really surprising to me. And then as the trial went on for day after day after day, certain members of the shadow jury,
dropped
I believe,
off.
Became disenchanted, upset, frustrated. They didn't like what was going on, and they simply said, "This is voluntary."
Yeah,
and they quit.
They were dropping like flies.
Dude, so I think Gasper Stair, who works at our firm, found out that there was a shadow jury, and he has no qualms about it. And he went up to them in the hallway, and in a non-confrontational manner, but he said like, "Oh, so you guys are the shadow jury. You're working for Kroger Corporation, huh?" And I think up until that time, they didn't realize that they were helping the Kroger. And I guess looking back, it was a good sign. Some of them stopped showing up. I think that they felt, my assumption is they said, I'm not going to help this corporation ruin this family any more than they already have, you know?
Yeah, and I think that was the sentiment that started when we were able to seat the full jury. And the last juror, who became our foreperson, talked about her husband and distinguish that roofing example of falling off a roof.
Yeah, this was absolutely amazing.
And that was the start of the shadow jury becoming a little bit skeptical about what they were each doing.
Yeah, so there was the jurors had been whittled down. There was only 2 jurors left in the gallery,
Yes.
right?
Correct.
Which means that
And I kept looking over my shoulder saying, all right,
it's
who's
one of these
left?
2,
It's going to be one of these
Yeah.
two.
right?
And I had done research on him.
Yeah.
And sometimes it's better to be lucky than good, right?
Yeah. So there was only 2 jurors left. There was a woman in the seat. Kroger still had a strike left.
Yeah.
We did not. So Kroger was up on us on strikes. They could choose to use a strike or not use a strike. There was a nice woman who was
Teacher.
A school
teacher.
teacher.
I wanted to strike her, but
In
we had
Lake
none
Orion.
left.
like a vocation speech pathologist
pathologist.
Right.
at Lake Orion.
I
Now,
wanted to
the
strike.
defense attorney was all Mr. Lake Orion. He had told her how, I represent Lake Orion. Do
His
I know
wife.
you, ma'am? Ma'am, did I represent you? You know, my kids go to Lake Orion. I live in Lake Orion, Lake Orion, Lake Orion, Lake Orion, Lake Orion.
Right. And just a tactical error.
Yeah.
In my opinion.
He's telling this woman all this stuff, and he liked her because he liked Lake Orion and he thought he had a connection with her. Now, Kroger Corporation had hired this like world famous jury consultant who flew in from California and I'm sure charged them probably $1 billion or gazillion dollars and was advising him. And we watched this all go down in real time. The defense attorney said, I want the jury as it is, right? I'm gonna rest with this jury. And he said, I saw him because we're sitting next to the counsel table. No, strike that lady from Lake Orion, right?
Oh, and there was visible disagreement between defense counsel and the jury consultant on this particular decision.
Yeah, he said, really? Are you sure? I don't think so. And I'm watching this all go down. And I'm looking back at the gallery, and one of the women in the gallery was, you get limited information on jurors, but they do tell you their profession. And one of the women in the gallery was listed as a business owner.
Mm-hmm.
Now, business owners, again, if we pick a jury based on paper, business owners are not good for plaintiffs, the people suing.
Mm-hmm.
Why? Because business owners have been sued before, because business owners have to buy insurance, because business owners may have had frivolous lawsuits, because business owners don't want to get sued, because business owners have to manage people and they have complaints and they're worried about getting sued and they can be more fiscally conservative, and worry about getting sued for a runaway jury, right? So this guy did what a person who looks at the paper does and said, we have a 50% chance of getting a business owner. Let's take it, right?
Exactly what happened.
So the jury consultant won. They struck the woman from Lake Orion, and who did they get?
I think her first name was Dawn, if I'm not mistaken.
The business owner.
And she was a business owner from Milford, whose husband happened to be
Injured.
a Brian Mierendorf.
Yeah. So the defense attorney's whole little improper analogy that he was using throughout voir dire, which I didn't object to, but it was improper, was that roof thing. Ladies and gentlemen, do you own a home? Yes. If you hired a roofer and that roofer came out to your house and fell off your home and then sued you, how would you feel about that? They're like,
Yeah,
oh, that would be horrible. That's ridiculous. That's frivolous.
Yeah.
Blah, blah,
And that
blah.
was a theme we anticipated, and I actually questioned Brian Mierendorf about when we were preparing for this case. I used that roofer analogy. I came up with that, and we looked at each other like, are we being bugged?
Yeah.
Because
it was
they came up
crazy.
with that exact theme in voir dire, and I was like shocked that they would think about that. But, whatever, great minds think alike as former defense lawyer. And when the breakthrough of this trial, in my opinion, in a major way, in terms of setting the tone, was the fact that she was asked about this roofer analogy
By the defense attorney.
and she said, well, my husband has gone to inspect decks at homes, and in one particular circumstance, the
fell
deck
through the
was
roof.
defective and he fell through the deck.
Yeah.
And he got hurt.
And so, no, that's not true. If I was a homeowner, I would want to make a visible and dangerous condition known to somebody
Yeah.
like my husband who's coming to bid and give an estimate on
Yeah.
a job.
And the defense attorney was just like,
It was one of those moments where I looked over at the defense table, and there was just a collective sigh.
The jury consultant looked like he was about to get
sick.
sued for malpractice.
It was so bad.
And so, he had used this improper analogy, and she's like, yeah, my husband was on a roof, and he did get hurt, and we did sued.
The best part is you were like, we're done.
No, I said, ma'am, can you be fair?
Yeah.
Yes. Okay, no further questions.
And we got our jury.
And they were a great jury. It was a fair jury. I didn't look at that jury and say, this is a pro plaintiff jury.
No.
It wasn't we had talked about it, and I think we said, this jury's okay. I think we said it's okay, which is fine, right? It's not, do I want a jury that's like super plaintiff, Jon Marko, super injured, John Eads? Yeah, I do. Okay, I want the best jury I can get for my client. And Kroger wants the best, super corporate anti-lawsuit jury. This jury was probably right in the middle, I would say.
Yeah, I agree. In Oakland County, it's very difficult to get jurors that are very plaintiff friendly, regardless of how they vote in the elections. In my over 40 trials in Oakland County, I only lost twice as a defense attorney, and it's very difficult to get jurors to give money.
Yeah. So we got a jury, we got a fair jury, we got a good jury. We're starting out the case. And one thing with this, going back to this shadow jury, and it bothered me because these people are shuffling in and out. It kind of was weird.
Mm-hmm.
And we did the research that they were not allowed to sit in the courtroom. Well, one day.
But they were.
One day, I'm sorry?
You said that they weren't. They were allowed.
That they were allowed to sit in the courtroom. And one day, normally after trial, we got to pack up. All right. Like, it's not in the movies where you just like fucking leave. It's like, we got to like pack up. Is there any other pressing issues? Let's deal with logistics. What are we going to do tomorrow? All right, Tyler, you got to get this ready. John Eads, you're going to be taking these witnesses tomorrow. Samantha, I need this file, that file. There's a lot of logistics. It's going to war. You got to have logistics,
yep.
right?
All hands on deck.
All hands on deck. Would go and would work after trial, would go meet at the office or Samantha's office or at my house, and it just never ends. You're all in. To be a good trial lawyer, you're all in all the time.
Yeah.
But this one day, I made a commitment. I was assistant coach to my 7-year-old son, Jon Marko Jr.'s baseball team. And I promised him I was going to be at every game, even if I had a trial, okay, which was a big commitment because he really, really good. And I'm trying to be better balancing because it's hard being a trial lawyer and being a dad. I'll just tell you that right now. And a husband.
Yes, it is.
As you guys know. But I said, Judge, I'm leaving. Right now, I got a long drive back to Grosse Pointe, and I'm going to a baseball game. In my suit and my Ferragamo shoes, I'm going to take off, put on some flip-flops, and I'm going to the game. And so I left as soon as the jury left, as everybody was filing out of the courtroom. And I was running to get on the elevator, and as I turned the corner, the entire jury was there. And the entire shadow jury was there.
Oh my gosh.
And I'm watching this, and look, so as a lawyer, we are not allowed, like the biggest no-no is you don't talk to the jury.
Right.
You don't tamper with the jury.
You don't get on the elevator.
I won't even get on the elevator with the jury. So what I would normally do is say, I would say, no, go ahead, and then take the stairs.
Yeah,
right?
and you always try and interject that before the trial starts to let them know, look, there are going to be times where we may have contact with each other. I'm not being rude.
Right.
We just can't have contact.
Exactly.
Yeah.
And so I walk around the corner. I stop in my tracks because I don't want to be by the jury. But then I watch this shadow jury who the judge just told, is not to interfere or impede the trial, get on the elevator with the real jurors. Which was entirely inappropriate.
Absolutely, because they serve as agents of the defense.
Yeah.
They're employees. It would be like all the defense attorneys getting on the elevator with all the jurors.
Yeah, and there was a handler, kind of like the shepherd, who was directing.
Yeah, the Gene Hackman of the runaway jury.
And I was shocked that he, as a professional who's hired to do this work, let that happen.
I wonder if he did it on purpose. Like, hey, why don't you go on the elevator and see what they say if they talk about something? I don't know. I'm just throwing that out there. But, I mean, that should have never happened.
Sure. The judge used the phrase appearance of impropriety a number of times during this trial. And certainly this could fit into that category if you're looking at this objectively.
And we're going to talk about, we're going to have a part 2 because this is good. And this is a landmark case.
Yeah.
But there was a lot of improprieties from the defense counsel, and from Kroger that we're going to dissect and go into next. But I wanted to talk about this shadow jury thing because I brought it to the judge's attention because we couldn't stop the shadow jury. I guess they kind of stopped themselves eventually once they found out they were working for
they did
for the wrong side.
Day by day we'd lose another one.
But the judge then told the shadow jury, did he tell them you are not to go, or did he tell the attorneys to tell them?
No, he made the handler come up because you brought it up the next morning, and the judge was very, very upset, and he made the handler come up under oath and say what was going on, and then he instructed them not to speak. I don't think there was ever an instruction because I don't think he wanted the jury to know that there was a shadow jury sitting there, even though it was blatantly obvious.
Yeah, and this is something.
I mean, but do you think they knew? I don't know. I mean, who the hell knows? I didn't know about a shadow jury, and I consider myself to be a pretty damn good attorney.
And just to kudos to the judge who is a relatively new judge who did not necessarily have the depth of experience of other judges to really, in a very measured way, think about how to deal with this.
What he did on on all the decisions, really.
Yeah.
He really took the time. And for our listeners, this isn't like time stops. For these judges, being a circuit court judge, a state circuit court judge, especially at one of the busiest circuits in Michigan, which Oakland County is, I mean, it was amazing the amount of work that he had to do. He was working as hard as us.
And his staff.
Yeah. And his staff.
Absolutely.
He only has one law clerk, I think. They only get paid one law clerk they can afford from the state budget. And they're researching. Then he's having to handle other matters in between our matter. I mean, it's insane what they have to go through.
They do. And they're handling both criminal matters and civil matters in this particular county, whereas other counties like Wayne County, the civil judges do not handle criminal cases.
Yeah.
So it's a huge burden on the judge, and it's a big challenge to have a big trial like this and then have all these other side issues going on while he's trying to conduct business. And a lot of circuits have judges that handle 200 or 300 cases on their docket. He has like 1,000 cases on his docket, and they get paid the exact same amount.
I know, it's crazy.
It is really crazy.
All right, look, we got a lot more to talk about on this landmark verdict against Kroger Corporation, but we're going to have to save it for next time. So you're going to have to stay tuned because we're going to talk about how things played out at trial, the crazy and wild gotcha moments. Lawyers say there's no gotcha moments. I've heard lawyers tell me there's no such thing as a gotcha moment. That's all in the movies. No, it's not. Okay, we're going to show you. In almost every trial we do, there's gotcha moments. We make sure that we get them. And we're going to break it down for you and then talk about how we got justice for the Mirendorf family against Kroger Corporation. You're going to have to stay tuned. We'll see you in another 2 weeks. If you like our show, if you need help, please share us with your friends and your family and go to markolaw.com, M-A-R-K-O law.com, or just give us a call. Pick up the phone. Call Marko Law, not Applebaum and Stone. Marko Law at 313 all sevens. That's 313-777-7777. We'll see you another 2 weeks here for part 2 of the Mirendorf special verdict alert on another Cases Gone Wild.